You're listening to Grown and Growing with Sonia Hamlin. What's up, everybody? Welcome back to the Grown and Growing podcast. I'm so glad that you're here today because I have a really great episode. And I know I say that with every episode, but I do feel like they're all great. It's like kids. You think they're all great in their own special way. But this episode is particularly important because it not only affects you, it affects the people I would say that you love the most in this world. So this week, we are talking about estate planning. I brought Sahmra A. Stevenson, who is an attorney here in Maryland, onto the podcast to help us learn the basics of estate planning. And Sahmra has worked with me and Derek on our estate plan. She put together a will, a trust, a living will for us. And we went through that process last year. And, I always knew that I needed a will or something, right? I knew I needed a will at the very least, but I put off doing it for so long because it just seemed super complicated. It just seemed very tedious. And I'm going to be honest, it's all of those things. It's complicated, it's tedious, it makes you think, but I feel so much better knowing that I have a plan in place for my kids, for my family. I feel like, okay, I can breathe a little bit easier when I'm thinking about the future. But, we often hear about estate plans when they are kind of tied to rich or wealthy people. We know all of those celebrities, or we can name a few celebrities who have died without wills. Takeoff was one of those who recently passed away, Aretha Franklin, Prince, people who had a lot of money and a lot of belongings or things, properties that, they died and left behind no instructions on how to divvy up or how to preserve any of their things. And I think people, when they think about estate plans, I think they either think that they need one or think that they don't need one for a couple of reasons. I've heard people say that they don't need a will because they don't have enough money or belongings, they're too young, or they don't plan on leaving anything behind for their loved ones. So why do they need to go through the process? In this episode, Sahmra and I will talk about why all of those are flawed reasons and why every adult over the age of 18 needs a will. I mean, when it comes down to it, you're gone. Yes, you're not here, but you also want to leave your family in a good place. You don't want them grieving over you and then having to untangle the mess that you've left, or having to guess what you would have wanted, or worse yet, having the courts dictate to your family what should happen with your money and your belongings. I think we've all seen, either through our own experiences or through the experiences of others, that funerals can tear families apart. And all of the negativity, all of the hurt really comes out at this time. And having a will or estate plan in place can really help alleviate some of that stress and could potentially save your family from a lot of infighting. So let me tell you a little bit more about Sahmra, and then we'll get into this episode. Sahmra A. Stevenson is the founder and CEO of S.A. Stevenson Law Offices, located in Columbia, Maryland. She and her staff are focused on fighting for happy families one day at a time. Sahmra approaches her work with the philosophy that whole and complete families begin with whole and complete people. Her practice focuses on the areas of family law litigation, trust and estates, and business law and formation. In 2016, Sahmra launched Wills on Wheels, Inc., the first mobile and virtual estate planning business model in Maryland. Sahmra has received several awards and accolades, including an induction into the Maryland Bar Foundation in 2014. She has also been recognized as a rising star by super lawyers for both Maryland and the District of Columbia every year since 2016. The Super Lawyers Rising Star list recognizes no more than 2.5% of lawyers in each state. So without further ado, let's get into this topic. Welcome, Sahmra, to the podcast. How are you?
I'm good. Thank you so much. Thanks for having me. Great tonight.
I am so glad that you're here because we met because you actually helped me with my estate planning.
I
We went
do.
through that process together early last year and we did it. And I was like, oh my gosh, this is something I definitely need to talk about on the podcast because there were so many things that I learned during that process that I didn't even expect. I thought we were going to do a little quick will and I was going to sign it and that was it. But no, we ended up with a whole package of things. And I thought, it is information that is so necessary for us is, we're getting up in age and we're, even seeing our parents retiring and thinking about retirement ourselves. It's definitely time or probably past time that we think about estate planning. So, but before we get into that, I want to learn a little bit more about you and your practice. So you have a practice that you have been the owner of for some time now, and you
Yeah.
actually, really have were kind of like a pioneer in, law firms going virtual before COVID, well before COVID, before anybody was really thinking about it. You coined the phrases "office without walls" and wheels on wheels. So,
Mhm.
can you tell us a little more about your practice and what you do?
Absolutely. I can't believe it's going on 10 years that I've been practicing and been out on my own as a solo for 7. Um, yeah, so in Office Without Walls, being completely transparent was like a survival technique for me. I worked in big firm.
Mm-hmm.
I worked in all areas of law, state's attorney's office, nonprofits, NAACP, big firm. And what I found was I was slowly dying trying to be a
Mm-hmm.
lawyer. And so when I went out on my own, there was a huge emphasis or for me, a big focus on being okay and being healthy and having quality of life that I could sustain, because otherwise it was either quit practicing law or find a way to practice law the way that worked for me. And for me, that was not chained to a desk. So
Mm-hmm.
I found a way to create a practice that allowed me to travel the world, and still continue to, support myself and be of service to people. And so that's where Office Without Walls came from. When I went out on my own, uh, I I had a practice and I had a backup W-2 job that I was
Mm-hmm.
kind of just holding on to and holding on to. And, God's will pushed me out of that nest. So it was kind of unexpected. So my last day at the job was March 30th, and March 31st, I hopped on a plane to go to Peru with my mom because we had agreed to do one exotic trip a year. So we took this trip. And so here I am. I have a practice I just started and I'm out of the country. And necessity breeds invention. I ended up finding out that you can make it work virtually. And so then that became my mission, was to show attorneys that you don't have to be chained to a desk with your ego behind you on your wall. That worked a lot better before I had all these plaques behind me. But you don't have to have your ego behind you on your wall to be an effective attorney.
Mm-hmm.
So I really advocate for the use of legal technology, both for quality of life for attorneys, like I've been describing, but also as a means of access to justice, which kind of brings on the whole Wills on Wheels portion you were talking about. Wills on Wheels I'm the founder and CEO of S.A. Stevenson Law Offices. Wills on Wheels is a branch of that was the first mobile and virtual estate planning business model in Maryland, where we took the work to the client. What I found when I worked for other people was um, there was a big problem with trying to get people to come to the office, and even if I could get them to come to the office and bring all the documents I needed, and then I got things drafted, getting them to come back to sign everything was another headache. So I took the middleman out and I went to people to do the consultations, go
Mm-hmm.
back to the office, draft, and come back and sign. Like you said, the pandemic brought about this whole world of Zoom, and so now we're even more effective serving people on Zoom and mobily as well.
Yeah, and people are used to it now, so it's no big deal to hop on Zoom or get on a phone call like we did, or meet in our dining room as we had a few months ago. But I
Absolutely.
love that you aspire to take a field that you never think about life balance, relaxation when it comes to law. It seems like it's so like they work extremely hard. You guys work extremely hard. It is 80-hour weeks. And so to have that and to be able to see somebody, if you go to your social media page, you see you working from different places, from the pool. And like I said,
The pool is one of
pre-pandemic,
my
you were doing
favorites.
this. That's pretty awesome that you were able to still do what you love, like do what you love and what you went to school for, and invested a lot of time and money into, and still find a way to live your life. I feel like that's amazing. So
Yeah, and
what?
that's where Office Without Walls came from. Was like, it was purely generic. It was I was leaving court one day, and I was posting, and I had a red suit on. And I said, red is my power color, and my office has no walls, because my sunroof was open, and I was planning to go work out in a park somewhere. So I was like, my office has no walls, and it was just a hashtag. And it kind of just took off from there. And from there, I traveled, and I traveled to 4 countries, 10 cities in 90 days, and didn't close the office once in 2017. And then in 2018, I spent 28 days going up and down the West Coast from Canada down to Arizona, and didn't close the office. And so it's totally possible.
I feel like that's how life should be lived. I need to figure out how to have a podcast without walls. So I wanted to have you on here to talk about estate planning, because like I said, I think it's so important. I recently went through that process with you, but I want to start off I want this to be a very estate planning for dummies kind of conversation. So how do you describe estate planning to people?
I feel like, so the word estate planning, and I feel like it's such a misnomer. It's misleading. Like, I like to I've been trying to recouch it as life planning, because it really is about making plans for our lifetime. Estate planning, people get this idea that you have to have this large estate for it to even apply to you, and all of these things. That's not the case. And why life planning is such a better term is because it deals with all affects, or all aspects of life, and what you might come into contact with, that whether that be actual death when that does happen, or incapacity, which is what a lot of people don't think about. And so as I'm also practice family law, or have historically practiced family law, and sorry, I'm trying to move away from the family law, but so being a family law attorney as well, I get a lot of guardianship cases in my office, and those are generally people who have not taken the time to think about those incapacity planning documents in advance. And what happens, and let me explain, incapacity planning documents are your power of attorney and your medical advance directive, generally a living will, maybe even a HIPAA waiver giving your loved ones authority to access your medical information. And these documents come into play when you are either unconscious or somehow unavailable to make these decisions on your own, and somebody has to step in for you. When you don't have these documents in place, naming agents to act on your behalf, what happens is your loved ones, if they're in a circumstance where you can't act for yourself and they need to care for you and provide love for you the way they want to, have to get the courts involved and pursue a guardianship action against you, which can take months and is a minimum $3,500, $4,000 to pursue that. So, having those documents in place is part of the life planning process, because we don't know what's going to come up in life. And even more than that, and jumping even deeper into how it pertains to life planning, is that these estate planning tools, things like trust, and I'm sure we're going to talk about these things tonight, can be used as tools for preserving legacy, and really making sure that we're creating gifts for our loved ones, or the ones that are coming behind us, and setting them up for a life of abundance and whatever they want to do, because of course that's what we want, what's best for them.
Mm-hmm. Yeah, it's interesting that you talked about being incapacitated, because to me, going through the process, that was the part that surprised me the most, and that is where we actually spent the bulk of our time figuring out, like, who's not just like who's going to make your health decisions, but who's going to make your money decisions. And is that the same person? Who's going to take care of the kids if they're still minors? And is that the same? Are these people all the same, or are they different? And then you're thinking about relationships. Who do you have the best relationships with? Who's the best with money? Who's the best with healthcare? So it was a very long and thought-provoking process to go through. But I want to start with, okay, so you have estate planning. Within the estate plan, I think the most basic thing that you can have a will.
Yeah.
Okay.
So if we're talking about planning for death, the last will and testament is going to be your most basic level of protection. And so if you pass away without a will, you're said to have died intestate. You did not serve as a testator if you're a man, or a testatrix if you're a woman, and create a last will and testament. The intestacy laws, meaning the statute, something written by a person, dictate how things will be handled, from how your property is distributed and who it's distributed to the taxes involved, and even how the estate is administered. So if you don't have a will in place, anyone who's opening an estate on someone's behalf is going to have to post a bond. With a last will and testament in place, it's going to be a nominal bond, usually $100. Without a last will and testament in place, it's going to be a percentage of the assets in the estate, which is several thousands of dollars. And so that can be
Hold on, repeat. So if you do not have a will, you have to pay $1,000 to the court or to
So
the bond
if there's no last will and testament in place, the person representative opening the estate is going to have to pay a percentage of
of the
the
estate.
value of the assets in the estate, which can be several thousands of dollars depending on what the assets are. And so that bond has to be assured and kept up to date each year. And those are fees that someone's paying on that bond in order for that to be accomplished. So your first line of defense in creating a less conflict for how things are left behind and less expense, because we're trying to leave as much as we can behind to our loved ones. We don't want that to get eaten up by the court costs and attorney's fees and all of those things. So your first line of defense is that last will and testament. Also allows you to name who's going to be taking care of things. Who is the personal representative? You'd be surprised how many people fight over what comes after you. Yeah. People want to be in charge and taking care of things. So, without a last will and testament specifying who your personal representative is, people left behind, you have to run around and get signatures from all the interested parties, giving them the authority to actually act on your behalf. And how crazy is that they have to do all of this legwork just to take care of you. Right. So just taking those extra steps in advance is crucial.
So when you have most people, so let's get this out of the way, because this is something that I hear often. I don't need a will because I don't have any money, or I'm going to spend all my money before I die. So therefore I don't need a will because I'm not leaving anything behind. Who should have a will?
Everybody.
Okay. So whether you have anything, if you're an adult,
age of 18, if you're over the age of 18, you need to have documents in place. Yes.
Even if you don't know what to put in it,
even if you don't know what to put in.
Okay,
yeah, and usually when there's any question about what to do, who to name in a certain place, what to leave to whom, I usually say, choose what you're okay with for the next 3 years. Don't worry about making it a lifetime. Just choose for the next 3 years what you're comfortable with.
Okay. So everybody should have a will. And you often hear about, celebrities dying without wills, or I think Aretha Franklin, like they found a will in her couch cushions and somebody wanted to bring that to contest it. So what constitutes a will? Can you write out something and have two people sign it and that's your will? Like how technical do you have to be with the process of a will? How specific does it have to be?
Technically, yes, you can write out your own last will and testament. It needs to be witnessed by two people, two individuals over the age of 18, not named in your last will and testament, meaning they're not named as a beneficiary and they're not named in any role like the personal representative. So you can write that out yourself. Are you going to possibly be missing a whole bunch of provisions that lend itself to things like what I was talking about the nominal bond? Probably. And so that whole nominal bond thing with your last will and testament is language that's in the will. Some other things that you might not think about are what happens if you have gifts that end up with a minor. So including provisions in that speak towards a trust being created in the event that gifts do end up with a minor. And then who is going to oversee that trust, which would be a trustee. How you want things left in terms of guardianship for minor children and all of those things. So yes, you can go do it yourself DIY method. LegalZoom, those are usually the people who end up in my office afterwards.
So they still end up coming to you, still end up in court.
Sometimes.
So it's probably best to work with an attorney to do it.
It's best to work with an attorney. Yeah, it's best to work with an attorney.
Okay. So will is the most basic level. And then above that, is it a trust? A trust is something you can kind of tack on to a will.
Yes. So yes, that's your next level of planning. So last will and testament, bare minimum. These are provisions for how things should be handled after you pass away. If you want to take it to another level, you can start planning and creating things that exist while you're still here. Those things are called trusts. So a trust is what I like to refer to as a revocable living trust. We'll start with that. I like to refer to as like a lockbox or a vehicle that houses assets. Let me explain. So I get a lot of people in my office who say, I want to create a trust because I want to avoid probate. So I find it very helpful to start off talking about the fact that you can't avoid probate. The only way to avoid probate is not to pass away. And so
what is probate? What is probate?
Okay. So probate is the estate administration process. So when you pass away, your estate or what's left behind has to be administered through the courts. really the courts are are going through your assets and making decisions with regards to your assets. So when people say they want to avoid probate, they're really saying, I want my assets to avoid probate, because you yourself can't. You pass away, it needs to be dealt with in terms of things being administered. But you can limit the court's involvement by creating a vehicle or the lockbox, which is what I'm referring to in this revocable trust, that houses the assets. So that holds on to them in the name of the trust on your behalf, but in the name of the trust. And because they are held onto in the name of the trust, they don't reflect a name that the court needs to deal with. So if you own the house you're living in and you want to sell that house, you sign on your name on a quitclaim deed or some other transfer of property document. That effectuates that legal exchange from one party to the next. If you're not here because you passed away, that's why the courts have to get involved, because they have to effectuate that legal transfer. And that's really about chain of title that goes historically back into property law and all those things, all the way back to like the UK. And so by putting those assets into a trust and changing the title on them, we avoid that process.
So basically, you're taking your assets. So it could be a house. It could, I think you said it could be can it be your retirement accounts, like a Roth IRA or investment accounts? What goes in the box? What can go in the box?
We can put them in the box. It's just a little bit different. So with the titled accounts, like cash accounts, brokerage accounts, anything reflecting your title, like reflecting your name in the title, can be changed. The ownership can be changed to the trust. The title can be changed. With retirement and life insurance policies, those proceeds aren't really yours yet. So at the time of what we do is we change the beneficiary on the name of the policy to be the name of the trust. And so at the time of your death, those funds get directed towards that lockbox instead of going to the beneficiaries directly. And where that benefits you is that whether you're giving a gift to a minor or a young adult, you can house these cash amounts in this lockbox, protected for your beneficiaries, instead of it being paid out to them directly at the time that you pass away. And so with a minor child, obviously they can't take because they're not 18, but maybe you have a 20-year-old who's receiving a $500,000 policy, having them receive that beneficiary payout age 20 might be more beneficial if it's received in trust and held for them until they reach a later age.
Okay. Yeah, that's good. So it's like you're putting things in the trust so that so another thing that people say is that putting things in a trust protects it from taxes. Is that true, or is that a misunderstanding of what a trust is?
So there is a gift and inheritance tax that assets are subject to when they go through probate. And because your assets aren't going through probate when they're in a trust, they do skip that gift and inheritance tax to a certain dollar amount. And that dollar amount is going to be dictated by whatever administration we have in office. Right now, it's a very high number. So unless you're looking at the $6 million range or higher, you're not really needing to worry about that.
Okay. Yeah. And so that's a benefit of if you have a will, and you put these things in a will and it's not in a trust, are you subject to that tax or no?
Yes.
Oh, you are.
Those gifts still have to go through the court. And that brings up another important distinction between a will and a trust, which are some of the privacy issues. Your last will and testament, while it's your private information while you're still here, and I recommend filing it with the Register of Wills and the court for safekeeping. When you do that, they put it in a fireproof box in the courthouse. Okay. If you didn't feel comfortable doing that, I would tell you to keep it in a fireproof box in your house. Either way, it's your private information while you're here. When you pass away, it becomes public record, meaning anybody can walk down to the courthouse and see how you've left things. The more and more we get into e-filing and everything being online with Maryland courts and courts everywhere, the more you can just look those things up online. But as an example, Baltimore City, if you walk down to the Register of Wills on the 3rd floor and walk into that room, they have like just books dating all the way back to like 1929 with everybody's last will and testament. So it's public information, public record. Might be important to you, might not be. That trust, those assets in that trust and what you decide to do with them, your private information for your eyes only. You might recall that movie Rain Man with Tom Cruise, where he goes to the reading of the will, because it's every interested party has a right to know what's in a last will and testament before it's administered. So nobody really does these reading of the will, but in the movie, he was at the house and doing the reading of the will. And he says, your father has left you the car and the rose bushes. And he's left $3 million in trust to a beneficiary. And he closes the book and he's like, all right, we're done. And Tom is like, what do you mean? What beneficiary? In the movie, he goes down to the bank and looks it up and finds out and goes down to the thing, which would hopefully never really happen. But that just goes to show like that's real. That's true to form. So nobody is required to tell anybody what is in your trust. And it is not, it's your private information used for your family and your eyes only.
Okay. So just to like recap a little bit. So a will is the most basic thing that you should do. Everybody should have a will if you're over 18 and you're putting, what you want done with your stuff. You ideally want to do that with an attorney, but you can do it with, you could write it by hand in your little notebook if you want and have two people who are not in the will, sign it and witness it, and that can serve as your will, although you do not recommend that.
I don't recommend that yet.
At all. We do not recommend that.
At all.
And then that is public, it's a public record, and it doesn't prevent, you have to pay gift tax on whatever you leave behind. Whoever is receiving those things have to pay some sort of tax on that. And then one step above that is a trust where you keep things that you really want to protect and pass down to, people you love or that are left behind. And that can include like your house. It can include like, as a pass through, like your life insurance or your car, if you want to leave it to your family, and it kind of protects things. Now that's the level I'm at. But what's the level above that even? There's another level.
You're at the upper level too. You just don't know it. So
okay.
What you created with me was called a revocable living trust. That word revocable, synonymous with control. You and your husband are in full control of those assets that are in that trust. You can put them in, you can take them out. And I know when I say put them in and take them out, I know it sounds real big. You can retitle them to the trust and you can take them back out and retitle them to your name. That's what I'm trying to say. So while it is revocable and you are in full control of those things, they are not, that revocable trust is not judgment proof, lien proof, creditor proof, meaning those assets are not protected from things like that. But at this time that the second of you to pass away, that trust becomes irrevocable for your children. Okay, so that's the next level. That's the next level. Taking it from revocable to irrevocable. Why? Because irrevocable takes the control aspect out of things. And when you are no longer in control of those assets become judgment proof, creditor proof, lien proof. And so when you pass those assets down to your loved ones, they remain in trust for them until whatever age you specified. Okay. And during that time period where that successor trustee, that other person you named that wasn't your child, is in control of delivering those assets to them, creditors can attach. So Junior goes to an Airbnb, leaves the water running with his friends over in Virginia Beach, and it becomes a subject of a lawsuit, and there's a judgment against them. Those assets aren't part of that. Okay. So that's how we plan for the next generation.
Okay. So the word revocable means control. Like
synonymous with control.
I have control. Like you said, we put stuff in our trust and we took okay. But correct. Irrevocable, it becomes irrevocable once one of us passes once
the second of you to pass away, because you gifted those assets to your loved one, but you didn't put them in control of it.
Right.
So they own them technically, but they're not the ones in control of it. And because you've removed that connection there can't be the creditors can't attach, those judgments can't attach.
So that's a question that I have on here. And it wasn't until later. If a loved one passes away, so maybe your parents or, a husband, are you responsible for their debts? Like, are the people who are living and inherit their assets, are they responsible to pay off their debts? And how do they control, like, where does the government step in and say, all right, now we know he passed away, so we're going to take your assets first before you get to him? Like, how does that work when it comes to debt and paying off a loved one's debt?
Creditors have a provisionary period from the time that an estate is open to come after the any kind of solvent account that's open with the state as part of the estate administration process. as a married spouse, they can come after you at any point in time.
Okay.
Because it's joint debt, as you know, for
Hmm.
liability reasons. So they might try and go after the estate, and if they can't settle it there, then they might try and come after you. And they know they're on top of it. They pay
So there's
attention
no
to
hiding.
those things. Yeah, there's no hiding from that.
Oh.
So
Hmm.
with the revocable trust, same idea. Um, Even if you didn't put your spouse's assets into the trust because of that marriage connection, you're subject to the same type of.
Oh. Even if the debt is only in their like if he has a credit card and it's only in his name and I have a credit card it's only in my name, they can still come after me for
The
his credit
laws of
card.
marriage. Yeah.
Oh, that's nice.
Hasn't been
Uh,
nice.
that's nice. But okay, so are you're so even before what about insurance money? So if you get insurance money, do they so if they leave you and haven't they have an insurance policy on their life and they leave and you inherit that, you get that, you have to pay debt on out of that insurance money, or does that insurance money just belong to you?
I don't want to speak on that because I'm not sure, to be honest with
Okay.
you. The life insurance
Okay.
money you're talking about?
Right.
Yeah, yeah.
Okay. That's fine, but just know that the debtors are coming after you, which is kind of unfair. I feel like it should just be like, okay,
Very
well,
unfair.
that person passed away.
Yeah, it's a reason why people don't get married. So.
Well, there's a lot of reasons now. I guess that add that on to the list. Okay, so let's talk about so we talked about some basic levels, a will, a trust, irrevocable versus revocable trust. Another important aspect of estate planning to me, which is probably the most important part, is beneficiaries. Choosing them, if you have kids, sometimes you kind of automatically want to pick your kids, but can you talk about the process of choosing beneficiaries and what people should think about when they are?
That's a good question. I don't know if I've ever been asked that question before. I mean, people usually default to their children, right? I think it comes down to the connections you have and what you're trying to instill or leave behind. So, when I have clients that don't have children, they're usually looking to nieces and nephews. And if those people aren't there, then they're looking to the children of friends and that kind of thing. It seems to always be leaving it to the next generation. But I think more importantly, what you need to think about, regardless of who you choose, is how you leave it to them. So
Okay.
going back to that conversation about trust, are we leaving it to somebody who is fiscally responsible and who's not going to just waste that asset? And if we want to leave something to somebody like that, can we safeguard it by leaving it in trust, naming a trustee to look after them? Then we can include things like spendthrift provisions. So those things would be if it was left to somebody in trust and a trustee is overseeing it, they would have the discretion to determine, well, this person is a danger to themselves and squandering these assets. They have a gambling problem. I need to cut this off until they've demonstrated for 6, 9, 12 months that they're absent. So I think it's more about thinking about how you're leaving it so that you're making the most use out of it. And so some of those trust provisions are very helpful for that.
How much detail can you go into? I think one of the things that we did is so obviously if we passed away, within our kids being 18, we still put parameters of when they would receive money. Like, I think it was like
Absolutely.
25, 30. Like we didn't give it all to them. Like if we were to pass away and they're 18, we
Right.
didn't give them all the money at 18. We
Right.
like,
Yeah.
kind
And
of,
I usually recommend starting around age 25 because it's like
yeah.
if someone
When the
had
frontal lobe is is fully formed.
mine took till 30s. So if someone had handed me a lump sum of cash at 18, I
25
would
is
have,
still young for a lot
right.
of, depending on how much money you leave in, that's a lot. Yeah.
Right. So if someone had given me a lump sum of cash at 18, would have been a Nissan Pathfinder because that was 2001 and that's what was hot back then. But I usually say around 25, mainly because tech, generally people are just getting out of school around 22. That's a couple more years to get an idea of what it's like to spend some money. And I mean, to budget and what is
Right.
required to live. I just say start off with a little bit at 25, not the whole thing. When you start off with a portion, regardless of the age that you start, you give the trustee who's overseeing things the opportunity to see what this person is going to do with the assets that they're being left. And so you can kind of make decisions from there about where to go. And then also kind of giving them infusions at ages that we think are going to be life event moments, like age 30 when we might be buying a house or that
Right.
kind of thing is also a good idea.
So you talk a lot about a trustee. Um, Obviously trust is in the name because they're not the person receiving the money, but they're the person to help distribute or make sure that the right people get the money at the right time.
Correct.
How do people choose that person? That's a critical person
It
because
is.
I mean, do they have total, how much control do they have? Is it possible for them to take everything
Yeah.
or are they, oh, it is possible.
They
Okay.
can, there's definitely problems with people, trustees not spending money. Honestly, they have a contractual obligation, they have a statutory obligation to act in the beneficiary's best interest. And so when you see litigation on these things, it's because people have been fleecing a trust account or, saying they're spending money on the child and doing some other things with it, or, that kind of
because I'm like, who's overseeing them? Who's
yeah.
watching them? Nope.
Yeah. That's that. Yeah. So, I mean,
Ooh, so you got to pick. That's the most important person then, that
yeah.
person.
Well, if it's a minor child that you're leaving things to, there's also going to be a guardian in play. So, making sure there's open and communication amongst your family members and between the guardian and the trustee is important.
Okay.
And the guardian and the trustee don't have to be the same person. So if you trust someone with rearing your child and instilling values and things like that in them more than you trust them with their fiscal responsibility, choose somebody else. Just separate the two rules. There's nothing wrong with
Yeah. I was surprised by when going through the process, I was surprised by how many people we had to consider. Like and it wasn't just with the will upon our death. It was also like if we were incapacitated, we had who was going to be our power of attorney to help us make healthcare decisions. And it wasn't just healthcare decisions. It was like the level of detail was like shocking to me. How long do you want to be on life support?
when we sat down and did those.
Yes. Do you want to be fed through a tube? How long do you want to be fed through that tube? I was like, I don't know. Do you want them to try to save you? Yes. How long? I don't know. Until I can wiggle my big toe. I don't like, it was like, there's a lot of, and then it was like, you're considering people in your family. Like I had to think through my family. I'm like, where do I want my kids to go? Is this person good with money? This person works in a hospital and I trust them to be more rational when making decisions about health. But this person, it was a lot to try to think about what needed to happen when all of this, and I appreciate the level of specificity because I would have never thought about that myself. It is very detailed and hopefully they follow it.
Yeah.
So
hopefully. And, and when it comes to picking, if we want to get a little bit more advanced in terms of like generational planning and helping educate the kids about the process, you might consider having trust that run to a certain age that allow a long enough period of time for you to have the beneficiary, the child, act as a co-trustee and learn about the money that they're receiving as well. So that's another consideration.
Yeah. And you can't really, I know this is not, you're not a financial planner, but I do think that financial literacy goes along with this whole process because ultimately it is about money and passing. And it's a very confusing, and sometimes I think purposely it's confusing on purpose.
It is.
But you have to have financial literacy be a part of this process, or you will have gone through all of this planning and paperwork because it's like this much paperwork. And when it's all said and done, you would have gone through all of that for nothing if the people you're leaving it to don't understand what they're being given.
Absolutely. There's something we talked about called lifetime asset protection, where that irrevocable status on that trust going to the kids can follow them for their lifetime if you choose to plan things like that. But if you don't educate them about what you've given them, they can absolutely destroy that.
Yeah, for sure. And I know with Black people and specifically, even if they have wealth, the odds of the person of the generation coming right after them sustaining that wealth is like 0.01. It's very small. Like the odds of them losing it and retaining that wealth, or the odds of them keeping and retaining that wealth and growing that wealth is very small, even if you leave them something. So that financial planning is super important. I do want to ask about estate planning when you are single, versus, so we talked about it through the lens of being married,
Mhm.
but what about single people, and what about people who are divorced? Like, I was
Mm.
confused about wills just being married. I'm like, do we get the same will? Like, he got stuff and I have stuff, and is it the same or is it different? I was confused. But how does a single person go about it? And maybe if they're single with kids, or a divorced people, really, like, that seems really messy. But
So, as far as being single and planning, I talk a lot, and I do a single series talking about just kind of getting your house in order while you're still waiting for that king or that queen to show up, and kind of having your documents in place. Very important, I think, and I think it actually helps you kind of omit like a sense of confidence and togetherness when you've gone through this process. You might speak to that about, like, did you feel that peace of mind after we finished the process and the kind of weight fall off your shoulders?
I
It
did. I
makes
felt
a
like an
difference.
adult. I mean, there's
It
still
makes a
some stuff
difference.
we need to do, but I'll talk
It
to you
makes
about later.
it makes a difference. So, and some of the considerations you might have, you might want to own property jointly with that person that you're going to fall in love with. And so making sure that, if you own property before that, possibly putting it into a trust so that's very clear what is marital and what is not marital, and kind of keeping your assets separate from that person. Um, and when you're thinking about planning, if you're a single person with children, thinking about planning, naming those guardians for those minor children, and coming up with an emergency plan as well. I like to put together what are called kid protection plans for my clients. And those are basically emergency planning, standalone guardianship documents for to make sure your kids are taken care of. Because so often when an estate plan is drafted, and I don't really know that many people who do the standalone guardianship documents, but when a estate plan is drafted, a guardianship is mentioned in the last will and testament. What if somebody doesn't pass away? They just don't come home. They end up in the hospital. The kids still need to be taken care of and not end up with child protective services. So do you have documents outside of your will? Because nobody's looking at that. You're not dead. Outside of your will that speak towards what your wishes are, and that give the authority for those people to act quickly, so the children don't end up in the wrong hands. Married planning as a divorced person. Well, very important to, if you've done some estate planning while you're married and things have changed, it's time to update your estate plan. Please don't leave those old provisions in place, because you might be leaving your ex-spouse in control over what happens to you in a moment of incapacity, and probably really don't want that. And your wishes have changed with regards to how things are going to be left. So that's the perfect time to talk about updating an estate plan, for sure.
Does that happen during divorce proceedings, or is that a part of divorce? Like, oh, we got to untangle this. If you had a estate plan together, like
no, it doesn't. It's not really necessary. I do get people who update their estate plans in the middle of being divorced, like going through the divorce, and then I always tell them to come back when the divorce is actually final and finished, because the estate plan can't supersede marital distribution and marital property.
Okay, because you're technically still married until you're not,
right,
and so it can't really change until
right.
then.
So if you put in your estate plan that this real estate property is going to Susie B, and it wasn't determined that actually is your property yet, that might not be possible.
Okay. So how often should you, like, if you're single and you're divorced, whatever, married and you still married, how often should you look at your estate planning? Like, is this an annual thing? Is this every 5 years, 3 years? Like, how often should you look at it?
Visit it annually, at the very minimum every 3 years. If you've gone more than 3 years without looking at your plan, you've gone far too long. It's always good to just take a look, make sure, and that includes designation of beneficiary. So, if you have those life insurance retirement policies and they're not being directed towards a trust, making sure that those beneficiaries are up to date as well.
Okay. What other advice do you have for people, what are some things that people don't consider when they're going through this process that you wish people would consider more?
I have a few. First, if you have an adult child and child that's 18 or older, you really need to be thinking about getting their documents in place. And so the last will and testament is probably the last thing you're thinking about for somebody that young. But I'm not even talking about that. I'm talking about a medical advance directive and a power of attorney that names you as their agent, because I'm guessing you're still footing some of the bill when they go off to college. But no doctor is required to talk to you if they end up in the hospital. You're not allowed to see their medical records. You can't access their banking records, pay their rent, all of those things. So make sure you have those documents in place for your adult child as they go off to school. Some things that people don't think about all the time.
Never. That's never crossed my mind. I mean, obviously my kids aren't that age, but I doubt that it would have. Okay.
Special needs trusts. If you have a special needs child, they're receiving benefits from the state. You need to make plans and either creating a last will and testament that speaks towards a special needs trust being created when you pass away, or you need to take the steps to create a special needs trust before now. And so that's in place in the event that something happens to you, so that that special needs child does not get disqualified from receiving their benefits from the state. Because if they were to receive that inheritance, it's considered income and it can knock them out. On average, it takes about 4 years to get somebody back on track with receiving benefits. So that's a very important thing for anybody with special needs children.
Awesome. These are great tips. And I really appreciate you talking us through the process of a will. Hopefully people will think about this as they're going through and planning all of the other aspects. I think, people don't like to think about death and everything, but I like the way you put it, where you said it's really about life planning, because death is the final thing, but there are a lot of things between you being healthy and you dying that can happen that would necessitate you having a plan in place. Mm-hmm. So I hope it catches on, because I do like it, and it's less intimidating than estate planning.
Absolutely. And one more thing, because you asked about planning for like divorced and single people. If you, whether you're a single parent or a divorced parent, if you're leaving things to your children, and your concern is the other parent having access to those funds, you need to take steps now to make sure that there is either a trust in place or a last will and testament that says you want someone else to be in charge of the money. Okay. Because most likely, if there's a surviving parent, they're going to be in charge of the kid and the money that's left behind.
Wow, I didn't even think about that. But the level of detail that you can go into when you're planning your trust, and it's not that you're trying to have control beyond the grave, but you're really trying to protect people from themselves and protect people from predators. So, yeah. Do people often try to control from the grave? Like,
hey, she used that term. She threw that out, and I think you were alluding to that earlier. But controlling from the grave is not allowed. Yes, people try and control all the time. So what you can do is you can leave behind what your wishes are, what your intentions are. It is our wish that these funds be used for. It is our direction to the successor trustee that they use their discretion in doing yada, yada, yada. But at the end of the day, we cannot control from the grave. Okay. So we can't say, you need to use $50,000 to buy this house, and you need to do this with this. And if she does that, then no, that kind of thing is not really allowed.
Okay. I was wondering, because I used to listen to Dave Ramsey, and he used to say, like, he put provisions, like if you're not Christian anymore, or if you, I think drugs is different. Like if you're on drugs, then you can't have it. But I'm like, who is determining that? And I mean, the Christian thing
yeah, that's an important thing to know. You can say whatever you want. Is it enforceable? That's really what I'm getting at. Is it enforceable? So you can say whatever you want, and if nobody challenges it, then technically that's what's going to go. But I'm guessing you're going to end up, if it's a substantial amount of money or something like that, you end up with somebody challenging you.
Okay. Well, you brought up challenging. Now I have a question, because with celebrities, you hear all the time, they're like, people are challenging. Even here in Baltimore, this big law firm, Angelo's, they're infighting, and all this. Who can challenge a will? They must be a family member to challenge the will, or can anybody challenge?
Interested party.
So they don't have to be related.
Interested party of the decedent is somebody that's going to be related. So by blood.
Okay.
Yeah.
So, okay, good. So a business partner couldn't contest a will, just yours.
No, there would have to be some kind of like operating agreement or something else giving some kind of contractual obligation.
Okay. So you can tell I watch a lot of movies. I'm like, what happens when this happens? Or
there can be other documents that cause somebody to challenge a will, like I said, an operating agreement, and it wasn't followed, and now the estate needs to be responsible for yada, yada, yada.
Okay. So how can people find you? So if they want to, they're like, Sahmra, I need a will. Girl, you convinced me. How can we find you, either on social media, or how can we find you on the web?
Yes, the website is SAS, S as in Sam, A as in Apple, S as in Sam, lawoffices.com. You can find me on Instagram, Office Without Walls, or SAS with Practice. And you can find me on Facebook, S.A. Stevenson Law Offices. The office number is 301-795-2728. And we're here to be of service and to help educate people. So, even if you're not looking to get a will, but you think somebody else needs to hear about this information, please call me. I love talking about it. I can talk for hours till blue in the face. They'll be sick of me by the time.
Do you talk to parents? They tend to be hard-headed. I feel like parents need to hear this. Thank you so much. And I will have all of that information in the show notes, so people don't have to write it down and remember. You can just go to the show notes. Thank you so much, Sahmra. I'm sorry, I keep saying Sahmra, but Sahmra, for being on the podcast today. I really appreciate it.
Thank you. You say my name beautifully, and I appreciate you having me.
Thank you. And for everybody else, I will see you next time.